Wonderful. So now your attendee one should pop up there, Stephanie.
Yep.
All right, we've got some people joining. Welcome, everyone. Happy Tuesday. Happy February. We've made it. Excited to see everyone joining us today. We'll get started in just a couple minutes as we let people join. But as you're hopping in, go ahead and place in the chat, give a hello, tell us your name, maybe where you're joining from. And I was thinking about a good prompt for this morning, and I was thinking, what is something that you have already checked off your to-do list today that you want to celebrate? So whether that's something you've been meaning to do or, showering, whatever it might be today, but something that you want to celebrate checking off your to-do list, go ahead and drop that in the chat. So just give us a hello as you're joining in, your name, maybe where you're joining from, and just something you want to celebrate checking off your to-do list today on this wonderful Tuesday. So go ahead and drop those in the chat. Say, hey, we'd love to see who is joining us. So, because sometimes, to-do list on a Tuesday or Monday is like, you can get a couple things checked off, you're doing great. So, as those are joining us today, go ahead, drop in the chat your name, where you're joining from, and maybe something you're happy that you checked off your to-do list this morning. And we'll get started in another minute or so. Hey, Marsha, thanks so much. Great to see you. See you, sort of. And we'll get started in a second. All right, I know a couple more people are joining in. All right. Hey, Christian, good to see you. Or I guess not see you. It's weird to say it that way. See that you are here.
I know I can't see anybody,
I
but
know.
here's the good news. Everyone's doing something on their to-do list. They're going to learn something new today, at
So
least one new
true.
thing.
So true. Yes, learn something new will be checked off all of our to-do lists this morning, which is great. Excellent. All right, so we got a couple more people joining. So if you didn't hear so far, go ahead and drop in the chat your name, where you're tuning in from, and we are talking a little bit about things that you're proud you checked off your to-do list this morning. And if you haven't gotten something done quite yet, you are doing it right now by joining this webinar. So we're so glad that you're here. And with that, I will jump into kind of my opening and some of our, little housekeeping items if you're joining us, especially for the first time. Looking at the list of attendees, it looks like we've got a lot of repeat webinar attendees. So we're so glad you're back. Thanks so much for joining us. We are back with our webinar program for 2022. It's the first one of 2022 here with Stephanie. So we're so excited. We're glad everyone is here joining us today. So if you don't know me, Shannon Barco, I'm the program manager for Women in Toys Licensing and Entertainment. And I also want to introduce virtually the other members of the WIT staff: Mary Kay Russell, our executive director; Peg Brom, our community manager; Allie Benham, our marketing manager; and Sandy LaBianca, our operations manager. And I'm so excited to introduce our presenter today, Stephanie Pottick. She is going to be telling us all about brand protection today, what things to look out for on your creator's journey, and some maybe cautionary tales to keep us out of trouble. I know there's so much I've learned from Stephanie, and so many things that I know you're going to all learn from her today. So we're very excited. A couple of things about Zoom. I know we've gotten pretty comfortable with this over the last going on 2.5 years, I guess, almost. At this point, who knows? Time's not real. But if you know, we've got the chat open. Go ahead and introduce yourself, where you're from, and anything we said today that you're excited to check off your to-do list. But also, you can use the chat for Q&A, as well as the Q&A box at the bottom of your screen for questions that we'll be getting to at the end of today's conversation and webinar. And we'll also be moving over to WIT Slack after the Zoom is over for any questions that don't get answered here live. Stephanie will be joining us over in the webinars channel on the WIT Slack to kind of ask and answer any other questions that you might have at the end. So with that, I will pass it over to Stephanie to get us started. And thanks again, everyone, for joining us today.
Thank you so much, Shannon. Thank you to you and your amazing team and Women in Toys for giving me the opportunity to speak to you all today. I'm really excited. I love doing these webinars. And also a shout out to the Nancy Zweer's Empowerment Fund for sponsoring this webinar. So thank you. And thank you for coming. So welcome everyone to Is Your Brand Protected? My name is Stephanie Pottick. I'm an attorney, instructor, and course creator who used to work in the toy industry on the business side. Because of my experience, I understand both the legal and business sides of branding, licensing, and creating and selling products. I again, like to thank you all for coming and for Women in Toys for hosting these. I think they're an amazing opportunity to learn and network and share. And just to round out, I am passionate. If anyone has ever heard me before, I love speaking at organizations, at Toy Fair, Licensing Expo. I just love educating entrepreneurs, inventors, and business owners on ways to build a strong foundation for their brands and their businesses and how to stay out of legal trouble. Okay, so here's what we're going to cover today. We're going to discuss some compelling reasons why you should care about protecting your brand. Then we'll identify some key things to look out for on your creator's journey so you can stay out of trouble. We'll go over the benefits of protecting your intellectual property, also known as IP, and I'll be calling it intellectual property or IP throughout the webinar. And then we'll briefly review some important IP basics that you should know. So my goal today is to teach you some practical steps without you having to get a law degree to protect what you've created so you can do business, launch, and license with confidence. Spotting even some of the issues I'm teaching today can really make a difference to your business. Now remember, you're not getting legal advice in this webinar, but you will be getting some helpful information that can help you achieve your goals for your brand and help you make better business decisions. And today we'll just be scratching the surface. There's so much more that you need to know, but unfortunately, we only have limited time today, so let's get to it. So you're probably here because you're creating something amazing that you're hoping will impact the market and maybe help you create a financially secure future for you and your family. If so, you're not alone. The creator economy has exploded over the last few years, especially during the pandemic. People are opening their own businesses in record numbers. The Census Bureau has reported that over 4.4 million new businesses were created in the US in 2020. That's over a 24% increase from 2019. And then in 2021, a record 5.4 million businesses were started. So if you've recently started a business, you're in good company. So nowadays with the internet and social media, it's so much easier to connect directly with an audience. That means there's more of an opportunity for you to sell products or services online. And with print and create on demand sites, sometimes you don't even need to find manufacturers or companies to license your ideas. That is pretty amazing. But because it is easier to get your products out there, and because there are so many people competing in the marketplace, it's even more important to figure out how to protect what's yours and help you stand out from the competition. And think of it this way. You're spending time and money and effort on creating and developing and finding ways to commercialize your brand. So doesn't it make sense to learn as much as you can so you don't lose everything you're working so hard for? Now, I'm not saying that you need to learn and understand everything there is to know about intellectual property or business or the law. Heck, I've been doing this for many years and I'm learning new things all the time. They recently passed the Trademark Modernization Act of 2020, and trademark lawyers like me are now having to figure out, well, what does that mean and what do we have to do and learn the new rules. I guess my point here is that you don't need to know everything, but as a savvy business owner and a brand creator, you should be able to at least identify and spot key issues and know how to ask, not how, but who. So you don't need to know how to do everything, but you should know who to ask to find out. And again, a shout out to Women in Toys. This community is amazing. There are so many opportunities if you have questions and need help, some guidance. The members are amazing and the leaders are amazing. Okay, so why am I bringing all of this up? Well, and this is really it, according to a Small Business Administration report, roughly between 30 to 50% of businesses get sued in a year. Many of those lawsuits have to do with breach of contract and intellectual property issues and infringement. So with record numbers of businesses forming, what do you think 2022 has in store for us? Unfortunately, there are plenty of lawyers ready in the waiting to sue. And as you may know, lawsuits can cost anywhere between $10,000 up to hundreds of thousands of dollars, and sometimes can get into the millions of dollars. Yes, companies spend that even in the toy industry. I won't mention, but I'm sure you can think of a couple. So what can you do to minimize the risk of costly lawsuits? And remember, for someone who's not a big company, a lawsuit can really make a difference. It can unfortunately harm your business. Some businesses go out of business. They declare bankruptcy. So any little things that you can do now to protect yourself proactively and spot big issues before you get into trouble is helpful. And the good news is, whether you're just starting out or you've been in business for a while, anything you do now will help you in the future. Okay, so we have a few poll questions because I want to see, well, Shannon's going to have to tell me if I can't see, but poll question 1, I want to find out about you guys. So the first question, oh, there it popped up. How about you? Do you own your own business? Are you working for a company, but thinking about opening your own business? Are you working for a company, but have a side hustle? Or are you working for a company and thought it would be good to learn about brand protection today? So I'll let you take a moment. I could do my little dun, 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 dun. Okay, I'll spare you.
Yeah, that's perfect. Great. So everyone can see that. Go ahead and fill out your responses to the poll. Looks like we've got about 2/3 of everyone who submitted their answer so far. So I'll give it another few seconds here.
Cool.
And then we will show the results.
Ooh. All right.
Get
Let's
your
see.
responses in. Quickly. 5, 4, 3, 2, and 1. All right. And I will share these results so you can see those.
All right. So, wow, look at this. So 43% own their own business. 43% are working for a company and thought it would be good to understand.
Great.
This is awesome. Okay, so I'm really happy to see this, because those of you who have your own business or thinking about starting your own business or have a side hustle, it's really important to kind of just you know what, for me, just being able to spot one issue can really make or break your brand or business. And if you're working at a company, understanding these issues really make you, I think, more marketable and allows you really to understand more parts of the business. So, okay, very good. Let us move on. Thank you for answering, everyone. Okay, so let's talk about some stories and what we can learn from them. So wrong one. Years ago, someone contacted me to review a contract she had already signed. So it was a licensing agreement that she had entered into, and she had a question on what royalties were owed to her. So I reviewed the contract, answered the questions about royalties, and then asked if she realized that she had signed away her intellectual property to the company that she was supposedly licensing to. So she immediately told me I was wrong, because that is not what the company told her was in the contract. And it couldn't have happened because it was called a licensing agreement. But I showed her the language in the contract that stated she gave away her rights, and let her know that it doesn't matter what the contract is called. It matters what it says. So when you sign a contract, you're pretty much stuck with it. This could have easily been prevented if she read and understood what was in her contract. Look, I've seen this many times. Companies will give you a contract and tell you it says one thing, when in reality, if you read it, it says something completely different. Now, I'm really not saying that it's always on purpose either. Sometimes companies don't know what's in their contracts. That's true. There's a disconnect between the attorneys and the company, but they don't know what's in it. They just think, oh, it's a contract, it's okay. But here's my point. Understanding what's in your contract before you sign it means at least you know what's going on. This is probably a situation where you'd really want to consider hiring an experienced attorney or someone with really savvy business experience and acumen to help you understand what the contract says. And if there's something you don't like, you can try to see if you can revise it so you are more comfortable to sign. Remember, signing a business signing a contract rather is a business decision. And by understanding what a contract says, you have the ability to choose whether or not you sign it, which leads us to our next poll question. All right, Shannon, load it up. Number 2, when you get contracts, do you read them thoroughly, hire someone to explain them to you, take at face value what the other party tells you is in the contract, or do you just sign them?
Excellent. Go ahead and get your answers in.
Oh.
A few more people. Give you a couple more seconds to go for it.
This is the most fun for me. I get to see what everyone is up to.
Yeah, and we get to watch it live, kind of coming in, which is great too. But all right, looks like almost everyone has submitted. I'll give you a couple more seconds. 5, 4, 3. Last vote's in. 2, 1. All right. There you go.
Yay! I am so excited. Look at this. 83% read them thoroughly. I'm really, and 35% hire someone to explain them. 13% take at face value what the other party says. That happens. And then 4% sign them. I am really, 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 really thrilled. I mean, that just made my whole day. So thank you. I'm really glad that most people read it. And if you don't, consider reading it. Okay, so next. Who here, I should have made this a poll, but anyway, who here has heard of Sweetwater Brewing? They're a brewery and beer company based in Georgia. So they have a logo that includes a fish, and that logo is used on their beer, their physical locations, and different merchandise that they sell to the public. Well, they were recently acquired by another company for $92 million. That's right, a brewery, $92 million. Now, after the acquisition, apparently the graphic designer who came up with the fish design they use on their logo claimed that he, the graphic designer, still owned the IP rights to the design and was asking for about $31 million, about a third of the $92 million paid for the company by the acquiring company. So, of course, this resulted in a costly lawsuit, which is playing out now. So the graphic designer was paid $500 to create the design. The question is, who owns the design? I'll let you think about that for a moment. So the general rule is that the creator of a work, like a logo or an illustration, owns the IP to that work unless they sign it away in a contract. So you may be asking, Stephanie, why are you telling us about a beer company? This is a Women in Toys webinar. Well, here's why. It doesn't matter what your company sells. It could be clothing, jewelry, toys, or services. This can happen to you if you're not paying attention. Think about it this way. What would happen if you hired someone and paid them $500 or $1,000 or $5,000 or more on a logo that they create for your brand? And what were to happen if your brand were to get traction and become successful? Did you know that unless you make sure you get, IP ownership in writing, the designer can come back to you and claim that they own the rights. And what happened to Sweetwater can happen to you. Don't let this happen to you. You need to know who owns what when it comes to your brand. So this includes anytime you hire a third party to create an illustration or a logo or a photo or video and on. And yes, third parties include family members too. Good to know. All right, Shannon, poll question number 3. Dun, dun, dun. I'd love to know, do you know if you own your IP? 100% I know. Well, I think I do, but I'm not 100% sure, and I have no idea.
Wonderful. Get your votes in. Couple more seconds. Couple more
Roll.
voters. All right. 5, 4, 3, 2, 1. Okay. There you go.
All right, look at this. Oh my God, I love you guys. You guys are amazing. Okay, 59%, 100% I know, could go either way. 23%, I think I do, but not 100% sure. You could definitely figure it out. And 18%, I have no idea. So hopefully the story that that we just talked about will help you kind of identify the issue and maybe just move forward. Moving forward, you can kind of keep your eyes open and understand that's an issue if you hire someone. Okay, perfect. So thank you. Thank you, Shannon, so much. Okay, so then here's another story. This one illustrates why it's important to know the difference between the main types of intellectual property. So someone I knew from the toy industry, and this was years ago, they told me they came up with a children's property and wanted to present it to toy companies at New York Toy Fair, which of course I hope will be in person next year again. They had a pitch deck and they took the prudent step of filing a copyright application to protect it. Now, they thought filing the copyright application would also protect the name. And that name was pretty incredible and really probably the most appealing part of the property. So they wound up showing the pitch deck to a number of companies at Toy Fair and contacts as well. And then one of the companies they showed it to was interested in licensing the IP, most especially that clever name. Fast forward a couple of months, right before they were about to sign a licensing agreement, they spoke with an attorney and realized that it was actually a trademark that would have protected the name. The copyright only protected the illustrations in the story. But by then it was too late. A competitor had already filed a trademark application for the same name. Now, my contact thinks that someone overheard them talking at Toy Fair and saw, I don't know if they saw the pitch deck, but they overheard the name, liked it, and then filed for trademark protection before my contact could. They learned the hard way that protecting a copyright does not protect the brand name, and that protecting the right IP through the right process makes all the difference. I mean, had this person just known the differences between the main types of IP, this whole mess could have been avoided. So let's just briefly talk about some compelling reasons that you should be thinking about protecting your IP. It gives you presumption of ownership. It helps you enforce your brand online and in the real world. I find that a lot of people really, especially now when their products are online, this is even more important. So there's something called the Digital Millennium Copyright Act that enables companies to enforce IP infringement on their sites. And I'm sure you've heard of Amazon. Amazon has a brand registry, but you can only sign up if you have a valid registration. And did you know that if you have a registration, you can have US Customs help enforce your intellectual property rights? Finally, it can be a ticket into court, especially for copyrights. And there's a recent Supreme Court decision that says you actually need a copyright registration to file an infringement lawsuit. Also, your IP is an asset that adds value to your business and makes it harder for others to steal. And it puts others on notice that you've done your due diligence and that if someone wants to license your IP, they're going to have to deal with you. That's pretty powerful. That's what you want. You want to make money and have them deal with you. Okay, Shannon, we're ready for poll question number 4. Have you protected your brands? Please let me know. I'm not at a point where I think it needs protecting. I don't know enough to know where to start. Yes, I protected at least some IP in connection with my brand. Or no, I haven't protected anything.
Great, we've got some answers coming in. Go ahead and put your answers on the poll. Give it a few more seconds here.
This one I'm curious to
Yeah.
see.
5, 4, 3, 2, 1. All
Dun, dun,
right.
dun.
You'll see them there. Go ahead.
Okay. 15%, I'm not at a point where think it needs protecting. 20%, I don't know enough to know where to start. 65%, yes, I've protected at least some IP and connect. You guys are all pros. I'm telling you, I'm sure. I'm so excited. See, being a member of Women in Toys is really good for your business. And 5%, I haven't protected anything. Okay, that's
So,
really good.
Stephanie, I'm going to stop you really quick. I would be really
Yes.
curious for those who answered that they've protected at least some IP in connection with their brand. If you're comfortable, I'd be curious for those who voted that to put in the chat, like what aspects you've covered and how. I'd be curious to see kind of what people, if they've protected some, like what ways have they done that? I'd be curious to see what people put in the
Oh,
chat
yeah.
for
Oh,
that.
let me know. Read them off.
So it looks like Lillian put both trademark and copyright.
Very good.
Copyrights of logos and drawings, but not trademark. So
Okay.
some good answers there.
Okay.
Patents and license agreements. So
Excellent.
definitely some different kind of variety, but that's what I was curious of is what kinds of ways have people
Right.
protected their IP so far. So
Yeah. Yeah. And thank you, Shannon, because that's actually it's a great question because every brand and product is going to have something different that's protectable. So some you really you may not have come up with a name and you haven't trademarked it, or you've come up with something and each, which we'll talk about in a second. So perfect segue. Um, each aspect of your brand may be able to be protected either through one way or two ways, or maybe even more than two. And it's really a business decision at the end of the day. I think it's really just important for you to identify what you have and then decide if it's worthwhile to protect it. And for those of you who answered that you're not at a point where you think it needs protecting, I do want to say that the sooner you protect what you have, the better. Once you've protected IP, you can feel more confident showing it to others. But until then, you're vulnerable to someone potentially, taking your idea. And then for those who don't even know enough to know where to start, hopefully the next few minutes will be very helpful for you. Okay, oops. Okay, so now that we've talked about some reasons why protecting IP is important, let's review some of the basic types of IP to help you get started on your road to success. Now, some of you may know this, and hopefully this is just a reminder or a primer, or maybe you'll also learn something new. So did you know that pretty much every brand or project you work on has some sort of IP, whether or not you know it? And understanding the main types of IP and what aspects of your brand or business they protect is an important first step on your creative journey. Essentially, IP is the basis for things like children's books, movies, toys, songs, musicals, plays, product lines, bags, cars, you name it. And IP can make you money as an additional revenue stream, like licensing, of course, with little or no effort, as long as you take steps to identify what you have, ensure you own it, and try to protect it before somebody else does. So the main types of IP are trademarks, copyrights, patents, and sometimes trade secrets, but we won't really be focusing on that today because typically when you're creating a brand or a product, only trademarks, copyrights, and patents will come into play. Okay, so we are at our last poll question, number 5, Shannon. And actually, knowing from the last one, this maybe anyway, how well versed are you with the different types of IP? I know all about this stuff. I only know a little bit, but wish I knew more. I always get them mixed up, or it's my first time hearing about IP. I have a feeling a lot of you know your stuff. But we did the poll questions before we did the last one. Got your answers.
Yep, this is great. All right, go ahead and get your answers in. Love having so many of these polls. It's always great to see where people are at. So this is awesome, Stephanie. Thank you.
Thank you.
All right. 5, 4, 3, 2, 1. All right, there you go.
Dun, dun, dun. Okay, I know all about this stuff, 38%. Good job. I know a little bit, but wish I knew more. Perfect, perfect. That's exact. You will learn something new. I always get them mixed up, and I'm so happy. No one put it's my first time hearing about IP. Excellent. Well, we're in the toy industry, and this is great organization. So, okay, excellent. All right. So let's start with a brief overview of trademarks. Trademarks are a powerful tool to protect your brand. Did you know that trademark protection can last as long as you continuously use your mark in connection with your goods or services? And if you have a registration, as long as you keep your registration active with the trademark office. I could seriously talk about trademarks for hours and hours and still not cover everything about them. So I'm just going to stick to the main points. Trademarks protect brands by helping identify and distinguish the source of goods and services. So that just means that you know where goods or services are coming from. So if you're thirsty and want a soft drink, you probably think of your favorite cola, either Coke or Pepsi. Each one is a trademarked brand. And if you buy Coke, you'll know what it's going to taste like. It's because of trademarks that you can recognize the differences between the different brands. So what do trademarks protect? They protect words, phrases, symbols, and designs, or a combination of those. Think of brand names like Google or Apple, taglines like just do it or can you hear me now? Logos like the Nike swoosh or McDonald's arches. Even characters like the Pillsbury Doughboy and the Jolly Green Giant are trademarkable. Plus, they're non-traditional trademarks that include things like colors, sounds like the NBC chimes, and even smells. And did you know that Hasbro has protected the smell of Play-Doh? That is so cool. So there are two basic ways to get trademark rights in the US. Common law rights through use in commerce, and by filing and getting a federal trademark registration with the US Patent and Trademark Office. Now, for you today, the goal is to be the first to both use and protect a mark by filing a trademark application. And here are a couple of tips on filing trademarks with the Trademark Office. There are 45 different classes of goods and services that you can choose from when you file an application. And you really want to make sure that you're protecting the right ones. And you should also know that the trademark application process is a process. It is not a one and done. You would be surprised how many people thought all they had to do was file an application, and that was it. If you don't act on the different deadlines, your application is going to abandon. And if that happens, you likely would have to start all over again by filing a new application. So now what about copyrights? What are they? A copyright generally protects original artistic or literary works. They can include photos, books, songs, illustrations, poems, blogs, and just so much more. Think of Harry Potter books and movies, Sesame Street characters, songs by the Beatles, the Nike swoosh, and even the tattoo on Mike Tyson's face. There is an amazing story with that. Some of you might have heard me already tell, but I'm going to save that for the next webinar. So if you own a copyright, you have the incredibly valuable exclusive right to reproduce, distribute, perform, and display the work, and to prepare derivative works based on that original work. So a derivative work is just a work that's based on the original. So if you've written a book and come out with a new edition, then that new edition would be a derivative of the original. Hope that makes sense. So the project that you're working on probably has numerous copyrightable elements, especially if you're creating a children's property, which you want to use in connection with books or toys and possibly animation one day. These might include illustrations and stories associated with the characters, and even the characters themselves may be copyrighted. Here's the default rule. A copyright exists the moment of creation, and the copyright typically is owned by the creator of that work. The only exception might be is if an employee creates something within the scope of his or her own employment. So you do not have to file a copyright application with the US Copyright Office to get a copyright, but sometimes having a copyright registration can be a powerful tool again, because it gives you the ticket to court if someone's infringing on your copyright. So depending on when, and this definitely, if you don't know this, it's a good thing to learn today. Depending on when you file your copyright application, you may be able to get statutory damages, sometimes up to $150,000. That's right, $150,000, and attorney's fees without even showing any damage, all just for the copyright filing fee, which is generally under $100. So very, very powerful thing to do. I think you get very good bang for your buck there. And unlike trademarks, which can theoretically be protected forever as long as you're using them, copyrights only last the life of the author plus 70 years. And for some work, it's 95 years from the year of publication. Okay, so let's round out our chat about IP with patents. There are two main types of patents: utility patents and design patents. You might have heard of plant patents, but I don't think that's really relevant here, so we'll stick to these. Patents protect novel and non-obvious inventions and original designs. So think of Dyson vacuums, super soakers, Spanx, Crocs. When I worked in toys, we had our own patents for a jewelry making item, a doll stroller, and a squirt gun, just to name a few. Getting a patent can definitely be a challenge. The application process for patents has many stages, and there are definite timelines you need to be aware of. So, for example, you must file a patent within 1 year of your first disclosure or public use of your invention, or within 1 year of the first offer to sell your invention. After that, it'll be too late to file for patent protection. Now, utility patents can last for up to 20 years from the application date, and design patents last for about 14 years after being granted. And finally, I definitely want to mention provisional patents, because they can be a powerful tool for you, even just for marketing purposes. So a provisional patent application is basically a 12-month placeholder for your utility patent. They cost less than a formal patent application and gives you an extra year to market your idea or work on your invention. But you'd have to file a formal utility patent within a year after filing the provisional patent. Otherwise, you'll lose your ability to file. Okay, I think we have time for one more quick topic. Here's a common misconception that can really get people into trouble. A domain name is not the same as a business name, which is not the same as a trademark. As a matter of fact, there's a whole bonus on this topic in our Protect for Success course. It's that important. I just want you to know that getting a business name registered in your state does not give you the right to use that name as a trademark. Same thing with the domain. If you buy the domain, that does not give you the right to use the business name or the trademark. Basically, just remember that getting one does not give you the rights to the others. Okay, phew, that was a lot of information, but don't worry, learning even one thing from today can help minimize the risk of you losing what you've worked so hard for, and can help you on your road to success. It can enable you to make better business decisions and help you add value to your company. Learning legal for your business is a necessary investment, and knowing what to look out for will give you the confidence you need, and that's priceless. Thank you so much. Any questions?
Stephanie, thank you so much. Oh my goodness, I'm like taking so many notes, and I've even seen your slides before this, but just getting your knowledge and kind of all the aspects around this is so useful and so helpful for so many of us. So this is great. Thank you so much for being part of this today.
Thank you. This was amazing. And honestly, I mean, I'm just so excited because so many people really, I'm so happy when people want to learn something. And a lot of people here know a lot of their stuff and are protecting what they have. So I'm excited about that.
Yeah, absolutely. All right, so we've got some good questions coming in, and if you have more questions, those who are joining us today, go ahead and drop them into the chat or into the Q&A box. I'm looking at both of them. So a question that came up is about Option agreements for IP. So if I sign an option agreement for my IP, does that mean that my logo is protected? And if that option expires, am I at risk? So how do option agreements and logo protection, how does that work together?
Okay, so they're unrelated, to be honest. So if you have an option agreement, that means that a third party, and by the way, sometimes it's hard if I'm misinterpreting the questions, feel free to, type, like reword them or something. And
Great.
again, I just want to say, without knowing all facts, I can't really give advice or say exactly because I don't know the situation. However, I'll give you as much information as I can based on what I'm seeing. So the option agreement, basically, that's more of what the story that I told about the person who didn't realize they signed away their rights. An option agreement will basically be, from a company, and the company will say, hey, give us some time. We want to take a look and see if we are going to use your intellectual property. If so, we're going to want to own it. So it just, it usually gives you some money, it gives them some time. And then at some point, the ownership, change of ownership can be triggered. So again, it's very specific to the contract. Now, the intellectual property that you're optioning, you've either protected it or not. It's not going to be protected by a contract unless the contract says that the other party has decided to protect it for you. But then if that's the case, who owns it? So I think there are a few issues here. One, what is the intellectual property? Which, I don't want people to share things that's not public yet. So, it's a rhetorical question at this point. So what is the underlying intellectual property? What, have you protected it? Do you own it? That should come first. And then what does your option contract say? And do you get, if they take it, do you get the option to have a reversion of rights if they don't use it or something goes wrong? So I hope that answers. It's
Yeah,
a tough
no,
one.
that's
They're
really
not really
helpful.
related.
It is, I think it's really helpful. And it's, the person who asked this question, I think Laurie, I think, um, wrote into the chat too that, we're all still learning. And so these questions, option agreements, there's so many different kind of words and lingo. And it's,
Yes.
this is why it's so great that we have Stephanie here to kind of help, navigate some of the different things and what they mean. So I think that's really helpful that, to know, that an option agreement, like, as you said, doesn't have kind of connection to the protection, but is more about kind of understanding what you're getting yourself into when it comes to those different agreements, and who is protecting what. So that's very helpful, and a great question. I mean, we really want to make sure that all of these kind of webinars is there's no wrong question. There is no question that, if you, feel like you've got it wrong or, are afraid of asking it, like, please ask those questions. That's what we create this space for, is this is an opportunity to ask the questions that you might be afraid to ask elsewhere. But this is, everything is fair game, to ask questions about. So,
you know what? I appreciate that. And by the way, you and what is it? Oh my God, you encapsulated everything perfectly. And when I was in toys, I didn't know this stuff. It's taken me many years from the business and the legal side to really understand. So yeah, no one should ever, it's better to ask. Here's the thing,
better
Shannon,
to ask.
it is
Yeah.
better to ask the question and then find out than
Mhm.
not know and then go, what the heck did I do?
Yeah,
Okay.
absolutely.
Yeah.
Yeah. So there's a good question about, work agreements. So I think this is another interesting one. So, when you have a work agreement and maybe there's like, is there IP involved in a work agreement? So when you, I'm not exactly, so I'll ask it exactly how I was asked, but I think I might know what they're, I might be able to reframe it a little bit. So it says, can you sign a work agreement and design a logo, but in that work agreement, the rights to my artwork is signed away? So I think I think maybe kind of broadening the question a little bit, out of those specifics are, when we work for a company or we kind of sign a contract to work for a company, who owns what and how do we kind of navigate that process as well?
Okay, so that's a great question. So I think you can look at it in the context of, is this person an employee or an independent contractor? So if the person's an employee, so if I'm working at a big toy company and I've created something, it probably says in my employment handbook or manual or whatever I signed, what happens with that intellectual property. So, and again, 9 times out of 10, it's the companies, and most states have that default rule. And if you're working for a company, then yes, they will typically own. However, if you're working on side projects, well, you can carve things out in that contract. You just have to, find out if it's acceptable, because the last thing you want to do is work on something and then find out, oh, I'm launching it, I've licensed it to a competitor, and then your employer says, hey, wait a minute, that's not yours. So that's an issue. If you're talking about someone's hired you as an independent contractor to create a logo for them, it depends what your contract says if you own it or not. The default rule is that the creator of a work owns it, and unless you sign it away in contract. So again, I think it comes back to, regardless of what the contract is called, what does it say? What do the terms say? What does it really mean?
And if somebody, I think going down that road of a question too is, I think sometimes, and I've heard this from other women I've talked to, is that we're almost afraid of what we can ask about or change in a contract. So I think it kind of begs to the question of the poll that you share, is that I kind of take it as what they give me and feel like I have to sign it. So what things are negotiable when it comes to a contract or a work agreement, or ownership, or all those different aspects that might be in a contract? What are we able to say, hey, I don't really feel good about this, can we talk about it?
Yeah, that's
What's
a
up
great,
for
yeah.
discussion? Yeah.
That's a great question, Shannon. So, okay, so it really, that's the best question. And that's a question you should ask every single time. Every situation is going to be different. So if you're signing a contract by a big entertainment company or toy company, they're going to want to change very little, if anything. So, but you pretty much go into it understanding that. And if you know what's in it, I can't say too much, but I've been in situations where I've helped review a bigger contract from a big company, and my client was a graphic designer, an independent contractor, and then after reviewing it, the non-competes were just so prohibitive that this person decided not to sign the contract. So there are things that you can try to go back on, but they're not always going to work. But if you don't ask, you won't know. That's really the answer to the question.
That's really helpful. Yeah, thank you. Great. So a couple questions coming in about patents. So there's one question about, is it true that many patents can be modified by changing a couple aspects of the design? So can you modify a patent based on like how much change for it to, I guess, not infringe, or can you get a different patent on that? And then a little bit of a question around, does that also include when it comes to its utility? So can you talk a little bit about kind of what the differences are in terms of infringement and what's possible in that
Okay,
realm?
so I really wish I could answer that. I don't personally handle patents. I don't file patents. I don't have a science or engineering background. My background is in toys. So I usually refer that to associates. I do know that, again, I think with almost anything, enforcement, so it's going to be what you get. What are you getting with your patent? I know a lot of times, people will ask, should I even get patent protection? I think that's why provisional patent is sometimes powerful, because you really don't have to disclose what it is. You have a year to kind of keep people guessing. But when it comes to filing, it probably depends on how novel your idea is, how much protection you think you can get. And this is the chance for you really to ask either patent attorney or people that have really gone through this, that have the experience. So I really wish I could answer. I'm sorry I can't answer, but I'd rather not answer and give you
Fair.
no answer than the wrong answer.
Yeah, and if that's something that people are interested in, I think we can definitely, on the wit side, look into bringing an IP attorney in to be able to answer some more questions potentially, or do another webinar as it relates to patents. So if that's something people are interested in, let us know, and we can try to work to find somebody. I think I know a woman or two that are patent attorneys, so it'd be great to see kind of a woman's perspective as well in that career path. So another question that I think comes up from, it's patents, but I think it's just IP in general. So I think something that was always interesting that I've learned too is that when it comes to protecting our IP, it's we can protect it, but it's also only so useful for how much you can kind of like fight infringement on it, is like maybe the wrong words, but it's so much about how you can actually kind of, if someone, I'm trying to think of the right way to phrase this, but if someone, is kind of infringing or using something, having your IP protected gives you the right to, kind of fight that. But that costs money too. So it's how do you weigh kind of the ability to have your IP protected, but also knowing that once it's protected, it's still going to cost more to actually, kind of like fight others who might be infringing
Yeah.
it. So,
That's
for lack of better terms, but I hope that
no,
makes sense.
no, it's, it totally makes sense. It's a business decision. That's why I think it's so important to really understand what you can protect, what protection you'll be getting, what's your situation. If you're licensing, then yeah, that company may want something protected. Otherwise, what are they licensing from you? So I think it's really situation specific. But yes, if you've protected, especially patents, um, you have to enforce your brand or trademark as well. It's your duty to
For
enforce
sure.
your
Yeah.
trademark in the
Enforce is the word
marketplace.
I was looking for, not fight.
Yeah, no,
Thank you.
it's and
I was
it's
like,
the
what's the
same.
word for
Hey,
it?
it's the same thing. But it's that's why it's such a challenge, and that's why I love speaking and opportunities like this, because it's people starting out or people who have smaller companies or entrepreneurs or inventors on their own. Whatever information you can get to help you make better decisions, it's just going to help you in the long run. So, I mean, I think really to answer it, Shannon, it depends on the situation. But yes, if you spend money on getting a patent and you don't enforce it, what'd you get the patent for? But and here's something else. This is where it's like, oh, cool. This is where when you find people that have been in the industry, that you can talk to, that you can get help, experts. So let's put it this way. And I've had clients do this, sometimes you'll own the IP, you'll license it, and then we put in that license agreement that the company will pay for enforcement. It just depends. So there are always opportunities.
Absolutely. Thank you so much. Okay, we've got a few more questions that jumped in here, so this is great. Um, let me just read through them really quick. Okay, so this is a question around, and you mentioned it too, when pitching your, let's say, toy ideas or concepts to companies, having, patent or protection is not just then about enforcing it, but it's also about having some value when it comes to, what you're pitching. So I'm curious of like what maybe stories or things where if you don't have kind of patents or things, is it still possible to pitch to license? Have you seen kind of things that maybe don't, concepts that aren't patented or don't have IP protected? Is it still possible to kind of pitch those concepts? What does that look like?
So that's a good question too. You don't technically, I guess, need intellectual property protection. I just wrote an article about this actually. You don't technically need anything protected, but what is that company paying for? What is that third party paying for? I mean, 9 times out of 10, they're going to want to see some sort of something protected. And you mentioned patents, but the truth is, if you're doing a children's brand, the trademark and the copyright are so much more important. I find that unless, it's something really unique that is, that will get patent protection, you have other IP that can really give you more bang for your buck, that will be able to kind of, allow you to make money from what you've created. So in terms of just, showing people, so it's there's a lot to unpack there. If you have something, the challenge really is to create something that you can protect at least something. I challenge you there. If there's nothing that's protectable, um, think about what you can do. Think about also, if you go into a license agreement, you probably, pretty sure you're going to have to indemnify the company for intellectual property infringement. So you do want something that you can hang your hat on as well. And then finally, if you really, you're like, oh, I don't know, this is a new concept, you can take a chance and show it to someone. They may or may not, honor not taking the idea from you or changing it in some way, or you can have some sort of non-disclosure agreement. However, there's no standard one size fits all. You want to make sure that it protects you in your particular situation. So that might be helpful.
That's really helpful. Thank you. And I know there's a lot of questions coming in about patents, so I'm definitely adding it to my list to find
Yeah,
some
I
additional
have
kind of
someone. I
expertise
have
about that.
someone
That's
perfect.
great. Yeah, we
Yeah,
can talk about that too.
yeah.
Because I know there's a bunch of questions coming in about patents, which is great. But I will ask this question, which is about so someone said they have their trademark and they've got their copyrights on their artwork at many different stages in development, but are curious about should they still be nervous about sharing any images of the characters that they've created or their art online or on social? One of the fears being that a large company, maybe, or anyone really could develop it more quickly, see it, make a derivative. But the question really also comes down to like, how does somebody build a brand without sharing images of it? Like, where is this balance of being able to be
Yeah.
protected and careful, but also share and build, and show the work that we're doing? So, would
Yeah.
love your thoughts on that.
Yeah, no, it's a really good question. And that by the way, that includes any intellectual property, right? Once you put it out into the world, what can someone kind of look at and copy without really stepping on your toes? And again, unfortunately, that was the worst day in law school when I realized the answer usually is it depends. I hate that. When I was going into law school from business, I'm like, what do you mean it depends? There should be an answer. But it does depend on the situation. I think if you've protected what you have, and you have trademarks and copyrights, if it were me, right, I can't tell anyone what to do, but if it were me, I would feel a lot more confident putting it out there because, I've protected the look, I've protected the characters, I've maybe protected the storyline. I don't know what you've protected with trademark and copyright, but I mean, I would feel better about doing it. But to answer the question, anyone can look at something and be inspired. Think about movies, right? There's like plots for movies. How many times in a year do you see like, oh, there are two really similar movies with very similar plots, but the lead is a male in one and a female in another, and it's a different situation. I kind of feel that someone was shopping an idea, and one movie studio takes it, and the other one passes, and the other one goes, oh, that was a great idea. It's a good concept. Let's change it up so it's not exact.
Yeah, it's that tough truth of, kind of ideas are sort of a dime a dozen, and, it's about being a creator and kind of continuing to create
Yeah,
more and more. I think it's interesting though to this question. Something I've been learning a bit more about is kind of the power that's really changing of the creators world and how there's so many more creators out there, and even with social media and
yeah,
things, there's the ability to kind of have the paper trail of like, hey, I was here first. And I think there's a lot of kind of communities that are built and protect, small artists and small businesses. When something is kind of ripped off like that, we're seeing a lot less of that because of kind of the accountability that can happen because of sort of this new creators economy. So it's really interesting time
yeah,
for kind of building your brand and being an independent creator and artist. And
yeah,
there's sort of this like community of the world that wants to protect more small businesses. So it's a really interesting things that there's some really interesting case studies about that that are happening for sure. So we're
yeah,
even seeing big brands work with smaller artists instead of ripping them off because they
yeah,
can see that it's a value, right? So there's some really interesting things happening in that
exactly.
too. So yeah,
Exactly.
all good things.
And you know what? I completely agree with that. That's why webinars like these and education is just super important. Whatever you can learn when you're working with those big companies, then at least, you understand, and you don't have to be unpleasantly surprised either.
Absolutely. Well, I know we're coming up to the end of our time and we've had some really awesome questions. So thanks everyone for joining. I'm going to download some of these questions before we jump off here to make sure that we've got them ready for if we are able to bring a patent attorney in as well. But Stephanie, thank you so, so much. And thank you for this great conversation. I always love the Q&A part to kind of like really dig into some of the different things that you talked about through the webinar. And thanks everyone for joining today and asking such great questions and being so curious. Like we said, this is always a space for asking the questions that
Yeah.
you might be a little afraid to ask anywhere else. And so we really want to make sure that this is a place where you can do that and feel really comfortable doing that.
Yeah.
So this webinar will be available in the webinar archives within the next 48 hours or so. And we'll send everyone who registered a link and copy of today's presentation as well. So definitely keep a lookout for that so you can kind of rewind and watch parts and ask more questions. And then we will be jumping over to Slack. So I'm going to put the link to that. I think, let's see if I
Oh
can
yeah.
find like
Thank
that.
you.
I thought I had it handy here. Sandy, actually, if you're on and can help and drop that link in the chat over to Slack, we'll be jumping over there to ask some more questions, and Stephanie will be answering some questions
Yeah.
in Slack. Ooh.
Yeah.
And that's my timer.
Oh, thank
And then the last thing I'll mention too is that we have a new WIT program that's starting up this coming Friday, and so this is our new WIT Casual Fridays. So this is just an opportunity to continue conversations, meet other members. If you're new to WIT, please join us this Friday. It's at 12:15 Eastern, and just a great opportunity to connect and network. Come as you are. You don't have to come with any kind of, prep or plan or anything. Just an opportunity to connect and discuss with other women in our industry. So we're looking
Yeah.
forward to kicking that off this Friday. Thank you, Stephanie. This
thank
was
thank
wonderful.
you.
We appreciate you.
Thank you everyone for coming. I think the slide is still up. Feel free to email me. We're going to Slack now, but I really, really, really love talking to all of you. So thank you for coming, and look forward to seeing you soon.
Wonderful. All right, before we jump off, I'm going to try to find that link. So if you're hanging out trying to find
Yeah,
the Slack, I want to get
I
it
need
right
that
now
too.
for everybody. Let me find that really
Thank you again,
fast.
everybody.
Yes, thank you all.
Thank
We'll see you over in
Yeah,
Slack.
and thank you, Shannon.
Oh,
Thank you for all your help. This Shannon makes this possible, and Sandy, who's hiding in the background, also.
okay, here is the link. Hopefully everyone can see that. All right, try that.
Got it.
And we'll see you over in Slack.
Yay! See you soon. Take care,
All right, thank
everybody.
you so much, everyone.